Real estate in North Carolina is treated quite differently after somebody passes away than compared to a checking account, savings account, money market, brokerage account, life insurance. And it's important to understand. So if you've just recently purchased a home or have owned a home for a while, one of the big things that you have to understand, number one, is how is that piece of property owned? Do you own it with a spouse? Do you own it with another person? Do you own it alone? You have to understand the ownership first before you can understand how the rest of the plan is going to work. Let's take an example. You own this real estate alone. You've passed away. I'm going to compare it to what would happen if you had a will and what would happen if you had a revocable trust, specifically for North Carolina estate planning. If this home is owned by you alone, once you pass away, if you have a will, provided it says where your real estate will pass, that beneficiary is going to need to have an estate opened in what's called probate court in order to legally take title to that real estate. That means that your executor named in your will is going to have to go to probate, file the will, get the authority to collect your assets and take control of your estate, and publish a notice to creditors. In North Carolina, you have to have 4 weeks of a published notice to creditors. But there are some counties that take months, 4 or 5 months, in order to appoint somebody. So until you get the appointment, you can't publish that notice to creditors. So now it's possibly 6 months since you've passed away, and your beneficiaries can't legally do anything, especially sell it. What you've essentially done is added a lot of financial stress and burden, because if there was a mortgage on that property, they have to continue paying the mortgage or it will be foreclosed upon. Mortgage companies don't care who the ultimate owner is. They will foreclose like they would have foreclosed if you owned it. Let's compare the same scenario, but change the plan that you had, and it's a revocable trust plan. That property is owned by you only. Once you create your trust, you do a deed transferring your ownership alone into the name of your trust. You have done 1,000,001 amazing things just by doing that one deed transfer. Number one, you've avoided having anybody to worry about how they're paying the mortgage because it's owned by the trust. Hopefully other assets are owned by the trust and there's money in that trust to continue paying the mortgage until they decide to sell. One of the bigger benefits is that they don't have to have a process in probate court in order to list that home for sale. So instead of waiting 5 or 6 months to get rid of the property, it could only be a month or so, but you've given them assets in the trust to cover the mortgage payments, property taxes, utilities for that shorter period of time. Now, the procedures and the options are going to be very different if you own it as husband and wife or you own it with somebody not a spouse, but with rights of survivorship or tenants in common. So it's really super important that the first way you understand what to do is to understand how your deed currently is and what your other options are once you do your estate plan. But do not neglect the real estate that you may have just purchased or have had for a while. You have to deal with that very, very differently. Click the link below, schedule your estate planning meeting. This way we can talk about all of the options that you have and you can protect probably what's one of the biggest investments in your estate. But please make sure that you're planning today because tomorrow is not promised for any of us.